A U.S. federal judge's decision to seek a fuller explanation from prosecutors before approving the dismissal of criminal charges against Indian billionaire Gautam Adani is a procedural requirement and does not signal that the case is likely to proceed, according to a senior U.S. lawyer who is familiar with federal criminal practice. He has stated under Rule 48A, the Department of Justice must obtain leave of court to dismiss an indictment, and judges can ask questions or seek additional briefing before the ruling. And he's also said that by itself is not unusual. The lawyer added that there is little precedent for a federal court compelling prosecutors to continue pursuing a criminal case once the Justice Department has decided it should be dismissed. The conduct of criminal prosecutions is constitutionally an executive function, and courts have historically accorded substantial deference to prosecutorial charging and dismissal decisions. The comments came after the judge overseeing the Adani case directed the Justice Department to provide a more detailed explanation for its request to dismiss the indictment. Brooklyn-based U.S. District Judge Nicholas Garifas has stated that federal prosecutors' May 18 announcement that they would no longer pursue the case which charged Adani with securities fraud and wire fraud stemming from an alleged bribery scheme did not sufficiently explain their decision. He has also stated that the judge's request should not be interpreted as a signal that dismissal is in jeopardy. In Adani case, the U.S. Department of Justice had submitted a brief argument seeking dismissal of the indictment against Adani and others. And he also added that the judge has given the DOJ time till July 13 to furnish a detailed explanation. Adani's has had in their recent letter to the court the numerous fatal weaknesses in the government's case. Those weaknesses were addressed in several presentations by counsel to the government that led to the DOJ's request for dismissal. Listen in to what expert lawmakers have had to say.
It's unclear. The rule seems to allow for that, but it's not, like I said, it's never happened in practice. And as a constitutional matter, it's unclear how that would even proceed. The judge would have no power to force the government to prosecute a case that it doesn't want to prosecute. It is a fairly routine process. The government, the prosecution, the Department of Justice has great discretion in deciding whether to bring a case and whether to dismiss it. But once a case is filed, the judge has to approve a dismissal, but I'm not aware of any instance where any judge has ever refused. I think if the judge were to deny the request to have the indictment dismissed, I think the government and Adani would both have the right to appeal. I don't think they will be that phased. Essentially, they gave a short answer, and the judge has asked them to give more of an explanation. So I think the Department of Justice shouldn't have any problem doing that. They're going to come back with better and a little bit more thorough analysis, and I think that will be sufficient for the judge. I would be very surprised if the Department of Justice gives an explanation that will not be accepted by the judge. It's unclear. The judge gave the government until July 13th to file a response, and if they take that full time, we'll see. They might respond sooner, which they ought to be able to do because this shouldn't require a lot of analysis on their part. But I think once that's done, the judge will take it under advisement and will decide how quickly to proceed. But I think we're probably talking about a couple of weeks, not months.